Okay, let's get started. Hi, everyone. My name is Kyle Berry. I'm the Director of Justice Programs at Alliance for Justice, an advocacy organization in Washington. I wanted to welcome everyone from around the country and around the world, if that's the case, and thank you for joining our discussion on forced arbitration. This has become one of our most important issues, one that we've been especially focused on over the past year or so. And the Google Hangout format is something that's very much new to us, and we're very excited to try it with this discussion. So we're going to move forward in two parts. We're going to start with a clip of our film that we've been showing over the past year about forced arbitration. It's called Lost in the Fine Print. And then we're going to move into a discussion with a panel of some of the top experts on this issue that we're really thrilled to have join us. Before we get to the film, I wanted to add that those watching can ask questions of our panelists. If throughout the clip while it's playing you want to ask a question, you can do so via Twitter. Either tweet at Alliance for Justice, which is at AFJustice, or you can just tweet with the hashtag forced arbitration. And I thought before we jumped into one of the stories in our film, I wanted to just give a brief overview of what is forced arbitration. Buried in everyday agreements for products, services, jobs, is fine print that says when you're harmed, you can't go before a judge or an impartial jury. Instead, a forced arbitration clause sends you to a decision maker that was essentially picked by the company that harmed you. And you're stuck with the decision that an arbitrator makes because there's no appeal. And ultimately, it's a rigged system that helps companies evade responsibility for violating all kinds of laws. Some of our most important laws, including anti-discrimination protections, consumer protection, and public health laws. So, and in this clip that we're about to show, you're going to see the story of a small business that was victimized by forced arbitration. This was in a credit card agreement between a credit card company and a retailer. And this small business took its case all the way to the U.S. Supreme Court, and the result was one of the landmark rulings on the issue. It turned out to be a very harmful ruling, as our panelists will talk about, but certainly a very important ruling nonetheless. And so with that, let's show the clip, which will take about 7 or 8 minutes. Thank you.
Many companies wanted to use forced arbitration provisions to avoid the court for a long time, but they needed help to do it. And they got it from the United States Supreme Court. In one case, owners of a neighborhood restaurant in Oakland, California, discovered that when small business goes up against big business, fairness is clearly not on the menu.
Good afternoon, Italian Colors.
Italian Colors in Oakland, California is the quintessential neighborhood restaurant, with a loyal following of customers attracted to the good food and friendly atmosphere.
Italian Colors is my American dream. I love what I do. I'm very passionate about it. I've been cooking now for 41 years. I don't know how to describe that. It's wonderful.
While business was good, profit margins were slim, in part due to the fees charged by credit card companies.
This started, I guess it's probably been over 12 years ago now. I was complaining about the new charges I was noticing on American Express.
What Alan and a lot of other merchants are upset by are these swipe fees. These swipe fees are fees that the credit card companies charge on every purchase Alan's record, and it eats into your profits.
What it means is an annual debit of between $53,000 and $60,000 that goes to the credit card processors, and that's quite a big chunk. Third, fourth largest expense.
Alan talked to Ed Zussman, a regular customer and San Francisco attorney, about the excessive and unfair fees the restaurant was required to pay for the right to use American Express cards.
He goes, let me look into it and see what we can do. And then he looked into it and asked if we wanted to file a suit, and I said, absolutely.
I think your customers would be, he said to me,
If it'll help other people and there's a chance that we could get these charges reduced, that we have to pay American Express, I'm up for it.
But Alan and Steve then learned that a forced arbitration clause buried in the fine print meant that American Express could not be held accountable in a court of law.
They sent a bulk mailer out that looked like a credit card application. And I guess the fine print in there was saying that it was no, if you had any discrepancies with American Express, you had to go through arbitration.
And to this day, I think Alan still doesn't have any idea what that paper said, if he got it, when he got it, where it is, if he did get it.
For years, federal laws have protected consumers and small businesses against unfair practices by powerful corporations.
These credit card companies have incredible market power. They have really the ability to dictate to small businesses like our client, Italian Colors Restaurant, what the terms of their contracts are going to be. And the merchant really has very little choice.
The bottom line is it's not just about the credit card fees. Everyone needs to make money one way or the other. It was about the way they went about slipping in the arbitration-only clause. Ben, thank you.
Italian Colors joined with other small businesses to seek justice.
Okay.
It's like, okay, I'm not going to back down from. I felt bullied, and that makes me want to stand up for myself more rather than cowering in a corner.
They couldn't believe their right to their day in court could be taken away, so they fought it all the way to the Supreme Court. And in 2013, the United States Supreme Court ruled on the case of Italian Colors versus American Express.
Supreme Court, they ruled against us and shut us down. They ruled in favor of big business.
The Supreme Court ruled the forced arbitration clause stood, even where it meant violations of important federal laws would go unpunished, continuing a trend of expanding corporate rights.
In the Italian Colors case, Justice Elena Kagan wrote this extremely strong, powerful, eloquent dissent. And what she did was she really set out that what the majority had done was a betrayal.
What Justice Kagan was saying is the Supreme Court is not even hiding what it's doing anymore. It is upfront, that it is telling all of you that if you enter into a contract with fine print and it says that you have to go to arbitration, and that means you can't bring your claim anywhere, even if it's guaranteed by law that you should be able to bring the claim, too darn bad.
It was basically giving big corporations a get-out-of-jail-free card as long as what they do is small enough. We prefer to protect a large business than to let a small business have its day in court. I mean, Italian Colors was not even allowed to have its day in court.
It took the wind out of her sail. I was pretty upset at Scalia for his writing. I hadn't read it yet, but right away that night we were so angered we put a Scalia Manhattan on the menu as a cocktail special, and we wrote underneath it, extra bitter and a little hard to swallow.
The Supreme Court has shown that not only do they not care about this problem, not only does the Supreme Court not want to fix this problem, but the Supreme Court has actually created the problem. It was essentially a green light to corporations to write these clauses into their contracts.
I got a lot of law professors from Cal came in, and they wanted to bring their students in and say, this is the restaurant, this is David that took on Goliath. Would I do it again with the amount of effort and energy put into it? I think I would say yes, I would.
The tide is starting to shift. Individuals are beginning to speak out. Consumer protection agencies are investigating. Congress is considering legislation. We have the power as consumers and the obligation as Americans to change things. Join our campaign. Spread the word to family and friends. Sign petitions. Get on Twitter and Facebook. Tell public officials forced arbitration violates our core democratic principles. What's been lost in the fine print can once again be found with strong voices, our voices. I urge you to use yours. I'm Robert Reich. Thank you for watching.
Great. So as I mentioned, we're joined now by an outstanding panel of experts to talk about arbitration and a number of issues related to arbitration. I'm going to start just by introducing the four panelists that we have. We're joined by Ellen Taverna. Oh, and by the way, I should say if the panelists could maybe just wave at the camera as I introduce you, that'd be helpful so people know who is who. We have Ellen Taverna. She's the legislative director at the National Association of Consumer Attorneys, or NACA. NACA is a nonprofit association of attorneys and consumer advocates committed to representing consumer interests. We also have Paul Bland on the panel. He's the executive director of Public Justice, a nonprofit that pursues high-impact lawsuits to combat social and economic injustice, protect the Earth's sustainability, and challenge predatory corporate conduct and government abuses. Next, we have Terry Chaw. She's the executive director of the National Employment Lawyers Association, or NELA. NELA is the country's largest organization of lawyers who exclusively or primarily represent employees in cases involving employment discrimination, illegal workplace harassment, wrongful termination, denial of employee benefits, and other employment-related matters. And finally, we have Christine Hines. She's the Consumer and Civil Justice Counsel at Congress Watch, which is a division of Public Citizen. Public Citizen champions consumer interest before Congress and also serves as a government watchdog. So I wanted to begin the discussion kind of jumping off of the Italian colors example, and I'm going to turn to Ellen from NACA first. So Italian colors involved a forced arbitration clause that was slipped into an agreement between a credit card company and a small business retailer. But we also see these agreements in consumer agreements with credit card companies as well. And now there's a federal agency, the Consumer Financial Protection Bureau, that's taking a look at this problem specifically in the context of consumer financial products like credit cards. So, Ellen, I'm hoping you can talk a little bit about the scope of the CFPB's work on forced arbitration and what it might be able to do to help solve this problem.
Sure. Thank you so much, Kyle, for this opportunity to talk today. So the Consumer Financial Protection Bureau was created by the Dodd-Frank Wall Street Reform Consumer Protection Act. And in fact, we're celebrating the 5th anniversary of Dodd-Frank this week. And the CFPB it's had its doors open for 4 years as well. So it's really great to speak about this issue this week, given there's so much discussion now about the CFPB. So the CFPB is designed to protect consumers and prevent unfair, deceptive, and abusive practices by financial companies. And what Dodd-Frank did was, first off, it prohibited the use of forced arbitration in disputes involving mortgage and home equity loans. And so that it banned it outright. And the CFPB issued a rule implementing that requirement. In addition, Section 1028 of Dodd-Frank, it required the CFPB to look into the use of forced arbitration clauses in connection with consumer financial products and services. So starting in 2012, the CFPB just did just that. It looked in a number of financial product marketplaces, including credit cards, checking accounts, payday loans, private student loans, prepaid cards, auto purchase loans, and other loans. And it looked at the use of forced arbitration in those contracts. And the CFPB provided plenty of opportunities for stakeholders, including industry groups and consumer groups and congressional offices, to weigh in with the CFPB on the study. And in addition to that, once the CFPB is completed its study, which it did in March of this year, the Dodd-Frank Act mandated or states that the CFPB has the authority to prohibit, limit, or impose conditions on the use of forced arbitration clauses in financial products and services under its jurisdiction. So now that the study is completed, which it did, the CFPB issued preliminary results the end of December of 2013, and then the final over 700 page comprehensive extremely evidence-based report in this year. And so that's where we're at right now.
If maybe you could highlight just one or two of the real headline findings from that report on which the CFPB may base their rulemaking, and maybe talk about some recent updates in whether the CFPB is moving forward and what the timing is, and some of the opposition that it's facing in moving forward with actually making the rule that it's authorized to under Dodd-Frank.
Absolutely. So some of the key findings, which is data that many of us have already known looking into the issue of forced arbitration for many years, and the CFPB confirmed that arbitration clauses are everywhere. They're very common in financial services and products contracts, and they impact tens of millions of consumers. Majority of these arbitration clauses have class action bans, so it eliminates the participation of class actions for consumers. The CFPB also looked and they surveyed consumers on their awareness and understanding of arbitration, and they found that overwhelmingly consumers are not aware of arbitration clauses in their contracts. They surveyed them on their credit card contracts, and they didn't know that there were forced arbitration clauses in their contracts, and they didn't really understand what the impact was of those clauses. Fewer than 7% of consumers surveyed understood that they could not sue their credit card company in court due to the arbitration clauses. Many believed that they could still participate in class action, which is not the case. The CFPB also looked at whether consumers were going to arbitration. It found that very few consumers were going to arbitration, especially for small dollar claims, which involve claims under $1,000. Very rare for consumers to bring those types of individual claims. They're difficult to bring. And so that sort of it relates to the examination that the CFPB looked into class actions and how that's related, because compared to class actions, millions of consumers received remedies for harms in class actions related to financial services. At least 160 million class members were eligible for relief over the 5-year period that the CFPB looked at class actions. And the settlements totaled $2.7 billion in cash for consumers in class actions. So the CFPB showed that class actions do work for consumers in these types of financial services cases. Another issue was that the CFPB looked at was whether or not arbitration clauses helped as far as the prices for these products, and it showed that eliminating arbitration clauses had not raised consumer prices for products. And in addition to that, the CFPB examined whether the enforcement, public and private enforcement, how that was related, and they showed that private enforcement complements public government enforcement. So basically, they explored whether or not private consumers and public officials were bringing the same types of cases, and whether or not there was overlap between those types of cases against financial companies. And majority of the time there was not, and when there was, it was private claims that were brought that were initiated first. So it really complemented public enforcement cases. So those are the big takeaways from the CFPB study. And what we know in Dodd-Frank is that now that the CFPB has completed the study, that if it's in the public interest and in the interest of consumer protection, then the CFPB must act. They must take action on the practice of forced arbitration. And we've heard the director, Richard Cordray at the CFPB, after considering the findings, has stated publicly that they will convene the rulemaking process, and that is going to begin soon. He's also stated that they would begin, which they've done with other rulemakings before, a small business review panel. So they'll go through a process where they provide input from small businesses and small entity representatives. And so they'll have a chance to provide input on a proposal that the CFPB would put forward on doing a rule around arbitration. And we expect that to begin soon.
Great, very helpful. Thank you. And so before leaving the CFPB and the CFPB's jurisdiction, I wanted to highlight one of the especially predatory and pernicious practices, which is the payday loan and the payday loan industry as a whole. Payday loans are one of the products that are included within the CFPB study that was released in March that Ellen just described to us. And I wanted to turn to Paul to talk about this sort of product and the problems attached to it in particular. And I wonder, Paul, maybe as sort of background, if you could start talking about or describing what the business model of the payday loan industry essentially amounts to, and why that's inherently harmful and unfair to low-income consumers in particular.
Okay, sure, thanks. Payday loans are just unbelievably expensive short-term loans. So what will happen is someone will go in and they will borrow, say, $500 and have to put down a payment, and they're supposed to pay back the entire amount in 2 weeks. So instead of a mortgage where you pay back, or a car loan, or a typical loan where you pay back a little bit of it over a period of time, you owe the entire amount in a very short period of time. So what happens is most people go into a payday loan thinking that they're going to be able to pay it off fairly quickly. And what turns out is that the vast majority of times, for example, one study found 19 out of 20 payday loans end up getting rolled over, meaning that when the 2 weeks go out, you can't pay it back. So in order to keep the loan, you actually have to pay another fee. And so the interest rates on these products are the lowest you'll see a payday loan will be 350%. We had a client one time who had over 1,300% interest rate on the loans. And so what happens is people get on a debt treadmill, and they frequently end up paying back to the payday lender far more than they spent, far more than they got for the original loan, and pay back several 100% interest. It's just a terrible product, and it's really harmful to consumers. And so what's happened with forced arbitration is the payday lending industry, it violates laws in certain states. So certain states have regulated fairly tightly. Some states have banned it. Some states sort of let them do whatever they want. In states where it's illegal, where it's considered usurious, where the interest rates are so high that they're not allowed to engage in them, it used to be that you could bring consumer protection cases on behalf of consumers who are being overcharged. And then you started running into the arbitration clauses. And the forced arbitration clauses were the industry's main way of defending itself. And so there's sort of two things that we saw in the payday lending area around forced arbitration. One was that most payday lenders used to use this company called the National Arbitration Forum. It was based out of a strip mall in Minnesota. So it basically replaced the court system as a little tiny company. And they were totally corrupt, essentially. They were completely on the side of the lenders. They would have these advertisements that they would put in magazines aimed at lenders saying, you know, basically, we're on your side. We're the alternative to a jury that might give some big award against you. And they went on for years and protected payday lenders and made it impossible for people to sue them until finally they were shut down by a law enforcement action brought by the state attorney general in Minnesota, which found they had this huge undisclosed conflict of interest. But one of the things that's troubling about forced arbitration is that since the company picks who the arbitrator is, there's no reason why you can't have another company like that, like the National Arbitration Forum, pop up again. And that's something that's really troubling. The other thing about forced arbitration clauses, and Ellen talked about this a little bit, is that they ban class actions. So as an example of what this means, we had 5 cases in North Carolina, which is one of the states in which it's illegal to have payday lending. And the judge could only handle so many cases at a time, so he had 3 cases go first and then 2 cases go later. So the first 3 cases went before the Italian Colors decision that's described in Lost in the Fine Print. And it used to be in America that if you could prove that an arbitration clause that banned class actions was going to gut people's rights to bring a claim under the consumer protection laws, that the arbitration clause wouldn't be enforced. So we had several cases in which we showed that if the arbitration clause was enforced, it would gut everyone's rights, and we were allowed to go forward and get around the arbitration clause. So for those 3 cases, we recovered $45 million and sent checks out to more than 200,000 North Carolina residents. The second 2 cases came up after Italian Colors. They were thrown out. Nobody got anything. So you had a world before forced arbitration, 200,000 people basically recovered money from having been cheated illegally, and after Italian Colors, forced arbitration meant that nobody got anything. And it's a pretty stark example.
Thanks, Paul. And we actually had a question from a viewer come in, so I thought maybe I'll stick with you and asked this question, which relates to the Supreme Court, and we've been talking about Italian colors in particular, but the question is whether forced arbitration has always been as prevalent as it is now, or if we've seen it increase, whether in the payday lending context or more broadly over the last decade or so, and what is the cause of that in your view?
So there was essentially almost no forced arbitration in consumer contracts until the very late 1990s, and they started appearing in credit card companies or in credit card contracts around 1999. Then they expanded to payday lending and other loan products over the next couple of years. They sort of spread differently from industry to industry. So, for example, in automobiles, you could buy a car and get a loan without having an arbitration clause almost anywhere in the country except for Alabama for some reason, until there were a series of cases which showed that African Americans were being charged essentially twice the finance charges of white people to borrow a car. Over millions of people, this data was consistent that black people were being charged more to buy a car for car financing. And so there were several class actions that forced them to stop that. And right after those class actions were filed, then all of a sudden every car dealer in America started using a forced arbitration clause. So they expanded to the point where now the CFPB study found that I think 96% of all credit card debts out there are subject to forced arbitration clauses. So they're omnipresent in the vast majority of consumer transactions.
Great, thank you, Paul. Terry, let me turn to you. We've been talking about forced arbitration mainly in the consumer context and how these clauses are harmful to consumers and force them out of the courts into arbitration. But these agreements are slipped into employment contracts as well, denying employees their right to bring claims against their employers in a court of law in front of an impartial judge and jury. So I wanted to first ask you about some facts and what we know about the use of this practice in employment contracts. We've been talking about the CFPB report and its findings in the consumer context. What do we know about how this is used in employment agreements? How common is it? Are employees aware of what they're agreeing to? And how does it affect their ability to succeed on claims when they're forced before an arbitrator as opposed to a court?
Thanks, Kyle. Those are great questions. First, I want to underscore that the term agreement is a fiction as it relates to forced arbitration in the employment context because employees are not knowingly and voluntarily agreeing to the forced arbitration provision. Employees have no power whatsoever to negotiate the term of the forced arbitration clause, and they are subject to forced arbitration as a condition of employment, meaning they have to basically relent to forced arbitration in order to get or keep their jobs. All of us, I think, agree that arbitration is appropriate to resolve workplace disputes when it is knowingly and voluntarily agreed to by the employee and the employer after a dispute arises. So you asked how common is forced arbitration. Forced arbitration clauses are found in job applications, in employee handbooks, in employment contracts, and in company emails that are sent to employees. The practice is widespread, affecting almost every segment of our nation's workforce, including minimum wage workers, highly compensated employees, and our nation's service members. There is one statistic from 2010 indicating that 27% of America's employers used forced arbitration clauses with their employees, covering 36 million workers. These numbers are probably higher now, given that the courts have interpreted the Federal Arbitration Act to apply to workplace disputes. A 2015 report by a national law firm that represents employers shows that the percentage of employers using forced arbitration clauses doubled from 21% in 2011 to almost 46% in 2015. And like Ellen and Paul said, in the consumer context, in the employee context, the employment context, these clauses are also banning class action lawsuits, thereby resulting in sharp declines in court actions brought by employees to vindicate their rights to be free from employment discrimination, harassment, retaliation, and wage theft. You asked, are employees aware that these clauses exist when they sign up for a job? In a poll conducted by NELA's charitable organization, the Employee Rights Advocacy Institute and Policy, and our friends at Public Citizen in 2009, we found that most people are unaware of the rights they are losing when they are forced into arbitration. In fact, more than 2/3 of those polled do not remember ever seeing anything about forced arbitration in the workplace. Even if workers are aware of forced arbitration, they don't necessarily understand the implications of the forced arbitration clause. Like consumers, most of them believe that they can take their employer to court when they believe their employer has violated the law, even if they are bound by a forced arbitration clause. It's also important to note in the employment context that courts have found employees to be bound by a forced arbitration provision even when they have not signed anything, so long as they continue to work for that employer. The last thing you asked was, how do employees fare when they end up in arbitration as compared to courts? A recent survey of lawyers who represent workers conducted by social scientists at Cornell University School of Industrial and Labor Relations found that the outcomes in arbitration for workers, win rates, damage awards, and settlement amounts are starkly inferior to outcomes workers receive when they get a chance to go to court. And I'm just going to read this one quote by a district court judge who said, "There is a reason that arbitration is the favored venue of many businesses for deciding employment disputes, and it is not to ensure that employees are afforded the best chances to have their claims adjudicated by a judge or a jury picked from their community."
Thanks, Terry. So it sounds clear how forced arbitration can prevent an individual employee from being able to actually vindicate his or her rights in court, or to gain access to court at all. But when these claims are forced into a private system of arbitration that's confidential, where there's no appeal, what does that mean for the development of the law? Because we're talking about some very important employment laws, including federal anti-discrimination and civil rights laws. Are there broader public policy considerations that we should be thinking about?
Yes, and another great question, Kyle. We at NELA and the Employee Rights Advocacy Institute for Law and Policy believe that forced arbitration is one of the most significant obstacles to the protection, enforcement, and vindication of employee rights. As you said, unlike our public civil justice system, the private and confidential nature of forced arbitration prevents the development of the law and other corrective measures that can be taken by the courts and Congress to ensure that our country's workplace laws are enforced as Congress intended. Simply stated, forced arbitration shields employers from public accountability because of the fact that there are unpublished opinions, arbitration is final and binding, and there is no meaningful review of or judicial review of an arbitrator's decision. Thus, unlawful employer conduct basically remains hidden behind closed doors and undetected by those who have the power to correct it. Just imagine what would have happened to Lilly Ledbetter had she been forced to arbitrate her equal pay dispute against Goodyear Tire and Rubber Company. Her case would have never seen the light of day, and the Lilly Ledbetter Fair Pay Act would not have been the first bill that President Barack Obama signed into law after he took office. There's one thing I want to mention since we're talking about the president. Last year in July, the president took a really important step to protect workers through his Fair Pay and Safe Workplaces executive order. Among many, many good things, one of the things that the president did through his executive order was to prohibit federal contractors who receive $1 million or more from the federal government from prohibiting them to force their employees to arbitrate claims arising under Title VII of the Civil Rights Act of 1964, one of our landmark civil rights statutes prohibiting employment discrimination, as well as tort-related claims involving sexual harassment and assault. I just want to underscore that the executive order is limited to those types of claims. It doesn't cover other kinds of workplace laws such as discrimination based on age, disability, wage and hour violations, but we are hoping that the president will make more progress in helping us to eradicate forced arbitration in the workplace.
Great, thank you, Terry. And just as we're moving along here, wanted to remind everyone who's watching that you can submit questions if you'd like via Twitter. Just tweet your question with the hashtag forced arbitration, or you can tweet at Alliance for Justice, which is at AF Justice. So Terry just mentioned an executive order that the president recently signed, which is helpful but limited in certain respects. And of course, Congress can go further. As we saw in the Italian Colors restaurant case, the Supreme Court has played a central role in expanding this problem and expanding the use of forced arbitration clauses. But the good news is that its decisions are based on a particular statute that we've talked about, the Federal Arbitration Act, not constitutional provisions. So there's room here for Congress to respond. And I'm going to turn to Christine now to talk about various ways in which certain legislators, at least, have attempted to solve this problem through legislation and what the status of those bills is right now.
Thanks, Kyle. I'm glad to be here with my colleagues to talk about this important issue. So Congress has actually taken steps in the past to eliminate forced arbitration in certain sectors. As it's been mentioned before, the service members are protected from forced arbitration for predatory lending due to a law that Congress passed. And also auto dealers are protected from forced arbitration in their negotiations on contracts with auto manufacturers. And we also have the employees of government defense contractors who are protected from forced arbitration for certain claims. So it's happened before that Congress can do something. They've proved it, that they can do something. So we have two bills in this Congress that we think would address very important, well, all of the issues for forced arbitration, to eliminate forced arbitration in consumer and non-union employment agreements. One of the bills is the Arbitration Fairness Act. It is sponsored by Senator Franken Senator Al Franken from Minnesota in the Senate, and in the House, Representative Hank Johnson of Georgia. This bill would eliminate forced arbitration for all civil rights, employment, consumer, antitrust disputes. So it would address the problem of forced arbitration for all of these claims. Another bill that is pretty new, it hasn't been introduced in previous Congresses, is the Court Legal Access and Student Support Act, which is also known as the CLASS Act. And this is a bill that came about after some negotiations with some activities with for-profit colleges. For-profit colleges have been under investigation for the last couple of years, and they've been investigated by the state, and they've been investigated by federal agencies. And they have been investigated for deception and for lying about job prospects to the students. And what's occurred is that these students have been stuck with a lot of debt. So another problem is that they use forced arbitration clauses in their enrollment contracts. So this CLASS Act would eliminate forced arbitration contracts, and it would tie the student aid programs, the federal student aid programs that these colleges use. It would restrict those schools that use those programs from restricting their students from being able to access the court system. That bill is sponsored by Senator Durbin from Illinois and by Representative Maxine Waters in the House. And these bills are all gaining support. They're gaining support in this Congress. It's an uphill climb. Right now, the Arbitration Fairness Act has 67 co-sponsors in the House, and it has 16 co-sponsors in the Senate. And the CLASS Act has 13 co-sponsors in the House and 4 in the Senate. So it will be an uphill climb. They're not likely to pass this Congress, but we continue to build support for these bills.
Thanks, Christine. I did have one more question from someone watching, and this may be directed at Terry, I think. So following the Supreme Court ruling this term recognizing a constitutional right to same-sex marriage, we've started to hear a little bit more about the need to pass protections for the LGBT community in the workplace, statutory protections, just like Title VII, for example. And the question is, assuming these laws are passed, granting these statutory protections, banning discrimination against the LGBT community in the workplace, what might a forced arbitration clause in an employment contract mean for the efficacy of these protections if they were passed?
Just so that I understand your question, you're asking if an employer includes a forced arbitration clause in handbook, whatever, and there's a law that's passed, what does that mean? Basically, that unfortunately, that law would I would say be rendered meaningless almost, because the person would have to be forced into arbitration. The rights of LGBT workers would be a developing aspect to employment law, like all of the other kinds of employment laws that have been passed in this country. They have been developed through the courts, and it's public, people know what's going on, and it would probably hinder the development of the rights of LGBT workers in the workplace. My advice would be to the drafters of this important legislation is to include a prohibition in the legislation against forced arbitration of those kinds of disputes.
Thank you, Terry. One more question, and this could be, I'll open it up to anyone who wants to answer, but if you're an employee or a consumer and you're worried about forced arbitration and what you're agreeing to when you take a job or buy a service or a product. Is there anything you can do, or is there any way to avoid these arbitration clauses?
One thing that you can do in the consumer setting is there are some types of businesses that don't use forced arbitration clauses. So, for example, in lending, if you can go to a credit union, most credit unions don't have them. So most consumers don't have on their radar screen at all the idea that a company is going to cheat them. But if you were thoughtful about it and sort of alert to the issue, and you knew that this was a problem, then if you had a chance, it would be smart to choose going, for example, to a credit union instead of to a company that's going to have a forced arbitration clause that's going to strip you of your rights. For employees, it's a lot harder, particularly if they're low-wage employees and they don't have a lot of options. But I do think that to the extent employees have any mobility, this should be something they should look at. If an employer is going to try and force them into forced arbitration, that sort of is a bad sign about the way that they view you and the way they react to you. And I think that if more companies had the idea that this wasn't just something that you could slip by people because no one knew about it, if there was a higher level of awareness among workers and among consumers that this was out there, then companies might start to be more cautious about the use of them.
Thanks. And did anyone want to add anything?
Well, I would just say, I mean, I think that Paul's right that there's some opportunities for consumers to go to credit unions for certain types of loans. For other types of loans, like payday and other loans, like private student loans that may not be available with credit unions. I mean, I would encourage people to really to contact their member of Congress, to communicate publicly to the Consumer Financial Protection Bureau that they want a rule banning forced arbitration and class action bans in their contracts. I think it's really important that people speak out and make known that this is an important issue to them. Unfortunately, because of the prevalence of forced arbitration everywhere in most consumer financial contracts, it is very difficult for consumers to do much. So I would really advocate for people to speak out publicly as much as possible on this issue.
Thanks, Ellen. So we've actually gone a little bit over time, so I think we will wrap up. I wanted to thank again our panelists for appearing today and for having this discussion, which was fantastic and very helpful. I wanted to thank everyone who watched, and just remind people that if you're interested in seeing the entirety of the film, Lost in the Fine Print, it's available on our website, afj.org. It's also on lostinthefineprint.org. You can also learn more about this issue generally on our website and on the websites of all the organizations from which our experts appeared today. And with that, I think we will close. Thanks, everyone.